Turning to today's programming, we've got Introduction to Design Professionals and Design Contracts presented by Scott Cahalan. I have the good fortune of now working with Scott, which I've been doing for a little over a year now. And he is definitely in the category of forgotten more about construction law than I currently know. He's a wealth of knowledge, and we're lucky to have him presenting on this topic. In addition to being a partner at Smith Gambrell and Russell, Scott is also a part-time lecturer at Georgia Tech, where he teaches the building construction students the basics of construction law. I know you're all muted and off screen, but join me in welcoming Scott. Scott, I'll let you take it away. Thank you again.
All right. Thank you, Todd. Just a couple more things about my practice. My practice is what I consider a full service practice, in that I draft and negotiate contracts, I provide advice during construction, and I also mop up at the end if we end up in a dispute, whether it's litigation, arbitration, or mediation. Let's go ahead and get started with our program. This webinar today will look at design professionals and design contracts and design liability in general. This program doesn't constitute legal advice, which really requires an analysis of the facts and applicable law, which is really going to be more nuanced than what we're going to get into today. First, a little housekeeping. I do encourage questions, but and I think there's a chat function on your screen. Go ahead and submit questions through chat. I'll handle them at the end of the program just to keep us on track. It just gets distracting trying to answer questions as I'm going along. If you have technical difficulties, you're probably wasting your time asking me to help fix them. I'm a little bit technologically challenged. My advice would be the normal help service advice is reboot or move your phone or turn the speaker off. That's about the full wealth of my knowledge on computer problems. You can also email questions to me at either of the email addresses on this screen after this program is over. It'd be better to ask the questions during the program because chances are there's other people that have those same questions. But I certainly welcome questions coming to my email, and I'll respond to them, to whoever asks those questions. This program's set to go to 60 minutes. If we go over the time, you're welcome to drop off if you need to drop off, or you're welcome to stay on. I'm going to try to get it all within 1 hour, but that can sometimes be a challenge. This is a pretty big subject. All right. There we go. Okay. We're going to start the program by looking at the design team's role on a construction project. I'll use the term design professional and architect engineers, and I might even go AE, interchangeably. We're talking about the same professionals in each case. Typically, the design professional of record will contract with either the owner or the general contractor. And it's a general contractor if it's a design build or EPC, engineering, procurement, and construction project. Otherwise, it's typically with the owner. Most of the time, I will treat the design professional as having contracted with an owner just to avoid having to split those two up. But these same concepts will apply to the contractor if it's a design build or EPC contract. Design professional services consist of really two main categories of services. We have design services and we have construction administration services. Unlike a construction contract where a contractor performs work, a design professional provides services, and that's an important concept. They call the drawings and specifications the instruments of service, and that's to distinguish between those documents being owned by the owner and being owned by the design professional. Copyright law would have the design professional own the drawings and specifications. They're just instruments of service, meaning that the contractor can use those drawings and specifications to build the project. Now that can be changed by contract. So the baseline design and construction administration services are referred to as basic services. But we also have additional or add services, which are optional services that can be accepted either at the onset of the contract, so the owner can accept those when they sign the contract, or they can be accepted during construction. Now, if you're using an AIA B101 form, they have some add services that are automatic, that the owner doesn't need to receive notice and provide approval before the architect or engineer would be entitled to additional money and possibly even additional time because of providing add services. I typically change those provisions. In today's use of iPads and in emails and things like that, there's really no reason the owner can't get notice of additional services. And the owner definitely has an interest in knowing that their cost is going up. So I will typically revise the AIA to say that, but that's just a practice pointer that if you're using the AIA contract, there are some additional services that are automatic adjustments to the contract. There are typically 3 phases of design that we have on a construction project. Sometimes the first phase is skipped, but it's conceptual or schematic drawings, and that's really getting the overall picture of what it is the owner wants and what the architect or engineer thinks the owner wants. Then and those may be elevations to show what the building is going to look like. They may be a site plan, but they're not detailed. They're not going to get into the size of the HVAC units or anything of that nature. The next phase is the design development phase, and design development is where you flesh out the design and you figure out how the utilities are going to run through the building and what size of utilities you need and what size of chases you need and things of that nature. So the design development is really where the rubber hits the road, so to speak. Construction drawings and specifications, that's going to be your permit drawings and specifications. So at that point, the conceptual is done, the design development is done. So you've figured out the size of your structural members and your utilities and things of that nature, and you're now adding the detail. Each phase builds on the previous phase with progressively more detail. At the end of each phase, the design professional typically delivers, and that's why we call them design deliverables, delivers that phases of drawings and specifications for the owner's approval and the owner's authorization to proceed with the next section. This is to make sure that the architect or engineer is on track with the owner's vision of the project, but it also establishes legally or contractually a right to an add service. If the architect or engineer has to go back and redo something that was in a prior phase that had already been authorized, then typically the architect or engineer is going to have a lot of work because they've proceeded based upon the presumption that they'd already, or not even the presumption, based upon the authorization that they had for that prior phase, and now they have to go back to that prior phase and fix it. So it's important when you receive the deliverables that you look at those drawings and make sure that it's what you want. This process is intended to verify the design professional knows what the owner wants and that the owner is willing to proceed on that basis. That doesn't mean the owner can't and even shouldn't make changes as they go. They just need to be aware that it may cost more money to make changes. If you realize that you didn't include a break room and you want a break room, well, then go ahead and add the break room, but it's going to probably cost you some money to do it because you don't have the plumbing change, going there. You might even have to change, some of the piping and some of the HVAC because you've added something that wasn't expected. All right. We're going to briefly talk about the difference between design and performance specs. In a nutshell, a design specification is a detailed drawing or specification that tells the contractor precisely what needs to happen. I put an example up here. It's a kid's play set. if you've ever assembled, a manufactured good, typically they'll identify each part and they'll tell you the exact sequence to put it in to install it. And if you do it out of sequence, then usually something doesn't fit or you've got extra parts or something, you have a problem. A performance spec, on the other hand, is going to be where the result is specified in the specifications, but the way to achieve that result may not be specified. An example of this may be sprinkler systems are typically a performance spec. The design professional will say that the sprinkler system in a building needs to conform to the applicable codes and laws and be leak proof. They may put some other things in there. But they usually won't identify the location of the sprinkler pipes. They won't identify the number of sprinkler heads or the routing of the piping, or maybe not necessarily even the type of material used for that piping. So that's a performance spec that the contractor is required to put in a sprinkler system that meets code. And from a design perspective, that's usually all you really care about. Is you don't want the fire marshal to refuse to give you a CO, a certificate of occupancy, because the sprinkler system doesn't meet code. So rather than try to design it, design professionals will usually include a performance spec. The key difference to look for between design specifications and performance specifications is that a performance specification gives the contractor discretion to change the design or to determine the design in order to achieve the result that's required by the performance specification. Courts look to the amount of discretion in determining whether a specification is a design specification or a performance specification. Just because you say it's a performance specification doesn't mean it's a performance specification. This issue usually only arises when we have a problem, whether it's a defect or something that happens where the contractor is going to take the position that I just followed the plans and specs, and the architect or engineer is going to take the position, no, that was a performance spec. You were required to achieve a specific result. How can two prudent construction professionals differ in their interpretation? Well, a lot of times, I gave you examples of a performance spec and a design spec, but a lot of times what we have are hybrid specifications that, for instance, they may say that the sprinkler system will be made out of stainless steel and it will be installed in the wall cavity and maybe even a wet system. And for those of you that don't know what a wet system is, a wet system has water in the sprinkler pipes at all times. And when there's a fire, the solder at the sprinkler head opens up, the solder melts, and then the sprinkler opens up and starts spraying water. A dry system has a valve that has to open once the fire or smoke is detected, and that's when the water goes into the pipe. Where that can make a difference is if those pipes are in the wall cavities, and the wall cavities are not well insulated, then we can have pipes that freeze and break. And that creates a big mess once you have sprinkler pipes that are breaking, especially if it's a wet system, and the water goes everywhere. So we end up in these legal disputes, and there's going to be a question: is this a design specification? Is it a performance specification? Well, that issue is going to hinge on the amount of discretion that was afforded to the contractor in achieving the result required by the drawings and specifications. Typically, the drawings and specifications will say that the system has to meet code and be leak proof, but they won't necessarily. But they'll also go further and require specifics, like they may, for instance, show that the sprinkler pipe is outside in the exterior wall, outside the insulation. Well, in that case, effectively, the pipe is subject to whatever temperature is outside. So, it's more likely it could freeze up in that situation. If the contractor is required to follow those plans and specifications, then it may be more like a design specification. If the contractor has the discretion to move that pipe and protect it from freezing, then it's probably a performance specification. All right. Before we leave the specifications, I also want to talk about proprietary specifications. Proprietary specifications is a specification that requires a single source of product or good or equipment. This is generally no problem on a private project, but on a public project where we require competitive bids and competitive proposals, and we don't want an element of favoritism, a sole source specification can be a problem. Georgia code does allow for sole source specifications, but the public entity has to justify its use of a sole source specification. An example of justification may be, for instance, where we have a government building or a government campus of buildings, several buildings, and they're doing some work, and maybe they have a Microsoft system, operating system in that building or in part of that building. Well, it wouldn't be unusual to come in and say, well, you have to install a Microsoft system as a sole source, because you don't want to try to have two different operating systems all running on the same computers. So that could create a problem. Or it could even be, like I say, a series of buildings where everybody is trained in Microsoft, and you don't want them to have to learn differences with Apple and have incompatibility issues. All right. We're now going to look at construction administration services and design liability issues in conjunction with each other. I'm not going to read this slide to you, but this is just some examples of what construction administration services are. Generally, construction administration services is anything other than the actual preparation of the design. It can be interpreting drawings and specifications, reviewing submittals, the various things I have listed here. But this slide is not intended to be all encompassing. So I've just listed some examples. So don't think that it's every construction administration services. It's just an example. All right. When we look at design liability, we start with the design professional services. And design contracts are a little unusual in that a architect or engineer may wear multiple hats on a particular project. There may be parts of the project where they're functioning as an independent contractor. There may be other parts of that project where they're functioning as a limited agent to the owner. And there may also be parts or duties that they have under the contract where they're functioning as a impartial neutral. So when we look at these liability issues, we have to answer the question, is the design professional, as they're doing this particular service, acting as an independent contractor, or they acting as a limited agent, or are they acting as a neutral? Because that's going to affect how we determine that liability. Courts typically consider that a design professional is acting as an independent contractor when performing the design services. An independent contractor, same professional may be a limited agent when they're doing things such as reviewing submittals, processing pay applications, and inspecting the work. And they're acting as a neutral when they're deciding disputes or requirements for the work. We're going to break this down a little bit so we understand what we mean by an independent contractor. So let's dig a little deeper. What's it mean to say the design professional is acting as an independent contractor? Well, an independent contractor, neutral, and limited agent are not employees of the owner. So they're not retained by the owner to be an employee. So all three of those functions are differentiated between, there's not an employment relationship. But when they're an independent contractor, they're hired to provide specific services or provide an end product of some sort. And the main element of an independent contractor is they have control as to how they're going to provide those services and when they're going to provide those services. There are some limits to that, because for instance, the owner may specify that the contractor has to work during, normal business hours or something like that. That's not controlling when the contractor is performing the work. Controlling when they perform the work is when telling the contractor, you need to do this at this point of time. You need to do that. Now, like I said, there are some issues there, but when we look at an independent contractor, control is really the main issue that we look at. What's it mean to say that a design professional is acting as a limited agent? Well, a limited agent, like an independent contractor, is not an employee of the owner, but they have some authority to act on behalf of the owner in the owner's dealings with third parties. And then when we use the word limited, so it's for limited purposes. It's not a general agent, it's a limited agent. Now, the gist of a limited agency is the authority. How much authority does the agent actually have, and how do they get that authority? Authority can be established in several different ways. I've listed 4 of them on the screen. And liability sometimes hinges on whether the act or omission of the design professional was an authorized act. So does that act translate or apply to the owner, or is it an independent act that the architect or engineer was not authorized to do on behalf of the owner? They may have authority to do it under their contract, but that doesn't necessarily mean they have authority to do that act under the construction contract. So an example may be ordering changes. Typically, an AIA contract gives the architect or engineer authority to make field changes, which are changes that don't affect the time and cost of the work, but they don't have authority to bind the owner to express authority to bind the owner to changes. Implied authority is similar to express authority, but it's a little trickier. Implied authority is the authority that, although not expressly given, is necessary to carry out the design professional's services. For example, a design professional may be obligated to inspect the contractor's work and reject non-conforming or defective work, which implies that the design professional has authority to approve acceptable work, or to make exceptions and accept non-conforming or defective work, which that can become an issue because the owner may take a position they didn't have authority to accept work that didn't meet the plans and specs. And so we're going to have that question, well, is that implied authority or not? Apparent authority is when the principal, which in this situation will be the owner, says or does or acts in such a way that an ordinary prudent person in the contractor's position would reasonably think that the architect or design professional has authority that the design professional doesn't really have. For example, an owner telling a contractor to go to the architect while the owner's away from the project may give the design professional or the architect apparent authority to act on behalf of the owner. That may not be the owner's intent. It may be that the owner is looking for the architect or engineer to be more of an admin to note the problem and then communicate to the owner, not to make the decision. So we would have that legal issue. Did the owner manifest that the architect or engineer had apparent authority by the owner's acts or by the owner's conduct or words? Now, an agent never has authority to give them, never has the right to establish their own authority. It's got to come from the principal. But a lot of times people will say, well, the architect said that he had authority to make this change, so I made the change. Well, that's not gonna fly. Ratification occurs when there was an unauthorized act that is later accepted or approved by the principal or the owner in this situation. That may be something such as, say, the architect or engineer has made a change that they weren't authorized to make, but the owner goes ahead and pays that change order or signs a change order authorizing that change. Now, the interesting thing about that is the ratification on one occasion may establish apparent authority on a future occasion. So sometimes when we get into these disputes, even though an unauthorized act was done, such as the architect or engineer ordering a change that binds the owner to a cost or time increase, if that's happened on one occasion, then it could establish apparent authority for the architect or engineer to make further changes because of that ratification. So those become very important issues when we're looking at ratification. So authority is one of the issues that we typically look at when we have design disputes. What's it mean to say that an architect or engineer is acting as a project neutral, or as a neutral? It's exactly like it sounds. The design professional is acting as an arbitrator, or they're making a decision. Now, under the AIA, American Institute of Architects terminology, the architect is typically, or engineer is typically the initial decision maker. So, for example, a design professional may decide things such as the requirements or acceptability of work that's been performed. Maybe the owner looks at the work and doesn't think the quality is very good, and the contractor says, no, this is acceptable in the industry. Typically, you'll go to the architect, and at that point in time, the architect has to take off their hat. The architect may have been the one to find the defect in their inspection, but the architect takes off that hat and becomes the project neutral, and it has to be impartial in making that decision. Other situations where the architect may act as a neutral are whether a physical condition of the site that's encountered by the contractor in the performance of the work is a materially differing site condition, or whether the owner has cause to terminate and to serve as and then also to serve as the initial decision maker. So I've already given you this next one. Why do we care? Well, we care because of liability. We want to know when the design professional is going to be liable to the party with whom it contracts, which could be the owner, could be the contractor if it's a design build or EPC contract. And we want to know who is going to be responsible to the third party. Typically, the owner has a contract with a third party. Design professional typically does not. But the question is going to be, is the owner liable to that third party because of the act or omission of the design professional? Design professional acting as an independent contractor is liable to the person with whom it contracts, which is either the owner or the contractor, for breach of contracts and for professional negligence. Now, I don't have a slide for professional negligence, and I should have, but professional negligence is a breach of the standard of care, which can be established by contract or by the common law. Under the common law, the professional standard of care is that an architect or engineer is expected to use the amount of care and judgment and skill that an ordinary design professional would exercise or use in that same or similar circumstances. And sometimes we even look at locality. It may be within the city of Atlanta. It may be within the state of Georgia. It could be within the United States. But what we're using for the standard of care is a standard to establish when that architect or engineer has exceeded or gone breached their standard of care. Now, I mentioned that a standard of care can also be established by contract. Don't do that. The problem is that architects and engineers, their insurance, professional liability insurance, sometimes called errors and omissions insurance, only covers the common law standard of care. Lawyers sometimes find it irresistible to establish a standard of care that what I call creates a super architect or super engineer. Architect or engineer will exercise the standard of care that an extraordinary architect or engineer would exercise, or that a highly skilled architect or engineer will exercise under the same or similar circumstances. The problem with that is you might establish that the owner is liable to the contractor, or that the the design professional is liable to the owner. But then when you look to insurance to pay it, the insurance carrier may deny coverage because they'll say, we didn't insure for this super standard of care. So my advice there is just don't change the standard of care. Keep it with the common law standard of care. The AIA actually puts it in their contracts, the common law standard of care. From a design contract perspective, I think it's important to not put anything in the design contract that's going to interfere with insurance coverage. Design professionals are typically LLCs, limited liability companies, or limited liability partnerships that they distribute their it's at the end of the year. They don't leave a lot of money within that business. So it's very important that if there's a major problem on the job, that the insurance be triggered and that you not have a drafting mistake in your contract that allows the insurance company to get out of paying coverage. Sorry if you represent insurance companies, but my view is that insurance is there for a purpose, and if it's triggered, then we should be able to look to it. All right. A design professional is not liable to the owner if and to the extent the design professional for a third party's liability, if the architect or engineer was acting within the scope of their authority and without negligence. A neutral is normally not going to be liable to either party absent negligence or abuse of power. Under the common law, the owner is not liable to third parties for acts and omissions of an independent contractor, but they are liable to for the acts or omissions of a limited agent. So when the architect, and that's why we care about what hat the architect or engineer is wearing, is if they have done something that causes an impact to the contractor, then the owner may be liable for that act or omission of the design professional so long as they were acting within the scope of their authority. So once again, the issue of authority becomes central to the liability issue. This screen just shows a chart. I've already pretty much covered how this breaks down, but this just shows design professionals' liability to the owner, professionals' liability to third parties, and owner's liability to third parties along the top axis. And then we look at independent contractor, limited agent, and neutral. I'm not going to read each one of these categories, but this table is aimed at giving you a quick reference to determine liability because it's tricky because of the different hats that an architect or engineer may wear. I now want to talk about some specific issues that we run into, some specific liability issues that we run into with design contracts. Obviously, this is an introduction to design professionals and design professional liability, so we're certainly not going to cover every type of issue, but some of these doctrines and principles are very important. The first case we're going to look at, the Hubert versus Aiken case, establishes what's called as the non-delegation doctrine. And this is an old case. It's in 1890 in New York. Hubert had hired Aiken to design an apartment building in New York City that contained steam heat, which was a relatively new technology at the time. The diagram on your screen shows how steam heat works, but basically there's a boiler down in the basement, typically, that's run by, usually nowadays it would be gas, but back then it was by coal. It could be wood burning, but usually coal, because coal will burn a little bit longer. But as that coal burns, you have to exhaust out the smoke and the ash, because otherwise it's going to create carbon monoxide within the house. So in this particular case, the architect had asked the contractor for the flue dimensions for the chimney. So the exhaust flue connected to the chimney. And the contractor provided dimensions for the chimney flue, and the contractor was a steam fitter, so they were experienced in the installation of radiator steam heat systems. But it turned out that the chimney flue dimensions given by the contractor were too small. And so what we had is that the smoke and the carbon monoxide were backing into the apartment building. So the owner had to pay to put a brand new chimney in, to tear down the old chimney and put a new chimney in. And the owner decided they weren't going to pay the architect's design fee. So the architect sued the owner for the design fee. The owner countersued for the cost of rebuilding the chimney. The trial court found that the architect had no liability for the undersized chimney because though they were architects by profession, they weren't experts at steam heating. So the architect in this situation had convinced the judge or the jury that the steam fitting was a specialty practice and that they could rely upon the contractor's opinion on the size of the chimney flue. The New York Court of Appeals, which is the highest court in New York, reversed because they said the plaintiffs are architects of standing who assume to be able to plan and superintend the construction of first-class apartment buildings to be heated by steam. The architect is duty-bound to possess reasonable skill and knowledge as to the design of all work that's in their design. This is really an important concept because it's saying that if the architect is responsible for the design of the building, then they're responsible for all parts of it. You can't start taking things out and saying, oh, well, the contractor can rely on somebody else. That doesn't mean the contractor can't contract with another design professional to determine the size of the flue, which they could have done. But in this case, they had gone to a non-professional, a contractor, to ask the contractor what size the flue needed to be. The contractor presumably didn't do any calculations. They just gave a number. The point here is professional responsibility to design a project cannot be fully delegated to non-professionals. All right, our next case is also a delegation case, but this is a case that arises out of a tragic incident that occurred in Kansas City when a fourth floor walkway fell and onto a second floor walkway, killing 114 people and injuring at least 186 others. Following that incident, the Missouri Board of Professional Engineers brought a license revocation action against the structural engineering company, the structural engineer of record on the project, and the president of that company that designed the walkway, alleging gross negligence, which, if proven, would result in both professionals losing their license permanently. Okay, the Kansas City walkway had, like I mentioned, 3 walkways. The second floor and the fourth floor were parallel to each other. So the fourth floor was directly above the second floor. The third floor was actually offset. So when the incident occurred, we only had the fourth floor falling on the second floor. There was some kind of dance party going on, so there were a bunch of people that were lining up on the walkway. What happened is the original design required a 6 steel bars go continuously from the second floor all the way up to the ceiling. And they would go through, because the fourth floor was parallel to the second floor, they would go through a box beam on the fourth floor, but the box beam was not intended to support any of the weight of the second floor. It was only supposed to be suspended or traverse continuously through the fourth floor. The contractor, and if you've ever seen the Kansas City Hyatt, it's one of these large open atrium buildings. And I don't know for a fact, but I would say it's like 20 stories up. And the contractor had a very hard time finding anybody that would provide steel bars, steel rods that were long enough to extend all the way from the ceiling. So they asked for a design change. They wanted to run the rod, and for some reason they could find one for the fourth floor, but they couldn't find one for the second floor. So the second floor was presumably another 20, 30 feet longer. So what they wanted to do and what they did is they ran the rod up to the fourth floor. They connected it to that box beam, and then they ran a separate rod from the fourth floor up. The problem with that is now you have weight of the second floor being carried by the same box beam that's also carrying the weight of the fourth floor. And once they loaded up that walkway with people at this dance contest, the weight was too much and it all collapsed. The licensing board, so the engineer took the position that it's common in the industry for the fabricator of the connections to design the connections of the rods to the box beam, which was true. But the licensing board determined in this situation that design of the connections is an engineering function, meaning that you can't just look in the steel manual and look at the tables and determine what's adequate to carry that load. They also determined that it was a special connection, meaning that it was a point load. So the rod was carrying weight beyond just a distributed weight. And it was a non-redundant connection, meaning that if one connection failed, if one rod failed, then the whole system would fail. There wasn't a backup system to hold those walkways in place if any of them failed. And the board went on to explain that a structural engineer may by custom delegate responsibility to a fabricator, a non-professional design connections, but to do that, there's two requirements. One is they must communicate that clearly to the fabricator in the drawings and specifications, and the engineer still remains responsible for the adequacy of the connection. So the engineer needs to check the calculations of the fabricator. You can't just delegate that authority without repercussions. You had to, the engineer of record had to make sure that the connection that was designed was adequate. In this situation, the engineer had not even run calculations when the fabricator asked if they could change the connection from being a continuous rod to a rod that went up to the fourth floor. So the licensing board ruled that the engineer had acted with gross negligence. I'm going to skip over the next couple slides. These are really just background information. What's a submittal? Well, that's like a shop drawing. But I want to get to the case and without spending a bunch of time. This slide just shows the liability with respect to the owner and the architect for injuries to a third party. So we're going to talk about the Wagner versus W&W Steel case, which is a project in Oklahoma, a hospital project, where the two workers were killed and another was seriously injured when a gust of wind caused a framework to collapse during construction of a hospital. The steel erector was working on all three floors at the same time. The problem was that they didn't have anything holding the steel together. The steel was being held together by gravity, which it's pretty heavy, so you wouldn't expect wind to be able to move it that easily. But you also had decking that was in place, so there was some lateral forces on that structural steel. They also had clips that were provided by the manufacturer, but the clips are not designed to actually hold the steel in place. They're just there to align it so that you have time to either weld it or bolt it in place. There wasn't an issue about whether the completed design was inadequate. The question is whether the construction design was inadequate. The survivors sued the owner, architect, and steel erector. Owner and fabricator were dismissed. Presumably they settled, but they may have been dismissed for some other reason. We don't know. Liability turned on whether the architect owed a duty to the workers who were killed to review those shop drawings and submittals to determine whether the temporary connections were adequate. The Supreme Court of Oklahoma held that under the various contracts, The contractor was required to review the shop drawings for conformance, for construction means and methods. The architect's review was just for general conformance with design intent. As a result, the architect did not owe a duty of professional standard of care on behalf of the workers with respect to reviewing the construction means and methods of assembling this structure. The architect had a duty to for the completed structure, but not for the temporary connections while it was under construction. From the delegation cases, you might presume that the structural integrity of the building is a design function that cannot be fully delegated. But when it comes to means and methods, that's something that the contractor has to be responsible for. And as a practical matter, if you think about it, the means and methods, the forces on a structural frame like this are changing as the contractor's performing the work. So, and the architect and engineer, and really it would be the engineer in this case, would not necessarily know the means and methods that the contractor intended to use for installation of that building. So anyway, the point here is that the architect does not owe a duty to the workers for the temporary connections. All right, this is just another background slide. We're talking about inspection of the work. And again, the architect is acting as an independent agent, or I'm sorry, as a limited agent when they're doing that inspection. But we're going to look at the Hudson School District versus Sergeant Webster case, which involves a common disclaimer that we see in design contracts. So the architect was responsible for endeavoring, which is not a real strong word, but was responsible for making some kind of effort to protect or guard the owner against defects in the work. But the design contract went on to say that the architect was not responsible for the contractor's failure to carry out the construction work in accordance with the contract documents. The architect was also responsible for assembling the contractor's warranties, for conducting 3 annual inspections of the building, and for advising the owner about maintenance and remedial measures that were needed for the building. Well, the architect failed to get the warranties, but it didn't tell the owner this until 7 years later. And when we're talking about the warranties, we're talking specifically about the roofing warranties in this situation. The roof was a built-up roof, meaning that it had 4 layers or plies. The specifications required that each section of the roof be done in small sections so that all 4 plies could go on more or less concurrently. Obviously you have to put them on one at a time, but the architect did not want a lag between each ply, because the problem is that moisture can get between the plies, and then it heats up in the sun, and you get bubbling, and you get welds that might break of that roofing material. Well, the contractor didn't follow the spec. They laid out large sections of the roof with 1 ply, welded all that together. There was even a circumstance where the architect had observed the subcontractor doing the roof, sweeping snow off of the roof and trying to sweep rain and things like that off the roof. So the architect observed those conditions, but didn't stop the contractor from doing them. Leaks developed like 2 months soon after occupancy, and then they progressively got worse. The architect hired a roofing expert to determine what the problem was. And the roofing expert told the architect the problem was that the contractor had not followed the specification for installing the built-up roof in small sections. But the architect didn't tell the owner that. The architect waited 7 years to tell the owner that's what the problem was. The architect actually lied to the owner and told the owner the problem was caused by ice dams that were forming on the roof, causing water to back up and enter the building through flashing and other details that were not intended to hold ponded water. Like I said, 7 years after the fact, the architect all of a sudden decided that they were going to tell the truth to the owner. And as you'd expect, the owner sued the architect. The architect's defense to the case was, I'm totally exculpated from liability by this provision stating that I'm not responsible for the contractor's failure to conform to the contract documents. In other words, I'm not responsible when the contractor installed these roofing plies in large sections rather than the small sections that were specified. The trial court bought that defense and they dismissed the claim against the architect. The Court of Appeals reversed, and they reversed because they said this clause is there to protect the architect from liability to an owner who seeks to recover from missed defects that might have been discovered by the architect if it inspected closer than required by the contract, but not to protect the architect from liability for any known defect that the architect then failed to disclose to the owner and in fact lied to the owner about. All right. Interpretation of plans and specs. This is a provision that requires the architect to act as a neutral. Architect will endeavor to secure the faithful performance by both our owner and contractor, will not show partiality to either, and will not be liable for results of interpretations or decisions rendered in good faith. Now that provision, it doesn't say this, but that provision is subject still to the professional standard of care. The architect or engineer can't negligently interpret the plans and specs, and they can't do it self-servingly. They can't interpret an error or an omission in the plans and specs as requiring the contractor to do something and be true to this provision. All right, we have about 5 minutes left. If anybody has any questions, I need to figure out where the chat function is. Ms. Smith, do you know whether we can open the mic? I don't see the chat function.
I have the chat open and it doesn't look
Oh.
like anybody has any questions.
Okay, well, now would be your chance to ask some questions. I know we've covered a lot and I've covered it fairly fast, but that's kind of the nature of getting an hour to present a subject like this that, you know, maybe could take longer.
We do have one question that just popped up.
Okay.
It says, do these standards apply to draftsmen as well?
Typically, well, the drafts person is usually working under the direction of the licensed architect or engineer. So technically, they're not going to apply to the drafts person, but as a company, they will, because the drafts person is an employee oftentimes of the design professional. In fact, the licensing laws require that the party, the architect or engineer that stamps the drawings, they're required to use their professional licensing stamp, that the work be done under their general supervision. So it is a violation of the licensing laws if you outsource the drafting of construction plans and they're not done under the general supervision of the person that stamps those drawings. It's a common practice to do that. But like I said, it's violation of the licensing laws, and the architect or engineer stamping those drawings could get in trouble. They could get sanctioned for doing that. And you certainly can't sell your license and have an unlicensed architect or engineer do drawings, and then all you do is come in and stamp them for a sum of money. We see that occasionally as well. The licensing laws are they're set up to make it a violation. Georgia's is both a holding out statute and an actual practice statute, meaning that you can't hold yourself out as being an architect or engineer unless you're licensed as an architect or engineer. You also can't perform those services. And actually the statute, the way it's written, the licensing statute, the trigger is you can't you can't bid on work unless you have the license. Which is an issue that I run into occasionally is contractors going to another state or architects or engineers. A lot of times they're going to get licensed if they get the contract. But the licensing law typically states that even making a proposal is holding out yourself as an architect or engineer licensed in that jurisdiction. So that could be a violation. It's not real hard to get reciprocity from most states on licensing laws, so we do see that. It's kind of a long-winded answer to your question about a draftsperson, but the draftsperson doesn't need to necessarily meet the standard of care, but somebody will. It's kind of like the delegation doctrine that we saw in the Kansas City case, is you can delegate that responsibility to a non-professional, but you got to check it. So, the draftsperson, if it was an independent drafting company, they may not be held to that same standard of care, but they might be. If they're unlicensed and they're not required to be licensed, then they probably aren't. But but somebody will be, whoever stamps their drawings, because if they're not licensed, then they can't stamp the drawings. All right. Do we have any other questions? Oh, here's the chat function. Okay. For some reason, it's on one of my screens. It's not on the other. Okay, next question is, should a design professional contracts include a provision tying all duties to standard of care? The author said, I've had architects argue that many duties are uninsurable, like the duty to design to a budget. That's not really true. There are cases where an architect or engineer can be professionally negligent for not meeting the standard of care. I typically don't touch the standard of care because I don't want to affect the insurance. You don't have to list that the designing to a budget is standard of care. Now, the issue is you're held to the standard of care of an ordinary architect or engineer under the same or similar circumstances. Architects and engineers are not construction professionals, so they don't have as great of a handle on the cost of a project as a contractor. So they're not held to an absolute standard. Now you can have a maximum price that you put in the contract. You can condition the architect's fee on coming in under budget. Generally, though, the issue is going to be whether they violated the standard of care. And there's no great rule of thumb, but I would say, if their budget if they exceed the budget by 10 to 15%, that's probably within standard of care. If it's 30% or more, it's probably professional negligence to not meet that budget. And it's an important issue to the owner because, designing way over budget, you now have to cut out a bunch of the design requirements, and there's going to be a big delay on doing the construction. So, the architect or engineer does have a duty of professional standard of care to at least meet, be within the ballpark or the neighborhood, the surrounding area of the ballpark on designing to a budget. But architects they typically price things based upon square footage. They say this is a Class A office building, so we're going to include $350 per square foot or whatever the current price is. Those are rules of thumb. They don't really take into account tariffs and some of the other pandemics and some of the other things that may affect costs. And the construction contracts will typically have a disclaimer about budget. So hopefully that answered your question. All right, let's see if we have any other questions. I do see that we're a couple minutes over right now, so like I said earlier, if you need to drop off, that's fine. Looks like I've answered all the questions. So I'm going to just say thank you for giving me this opportunity to present today. I hope you learned something during today's presentation. Like I said at the beginning of the program, feel free to contact me at either of my email addresses should you have any questions about design responsibility. And that's it. I think you can disconnect. Thank you.